Well, this case, maybe we can see the glass half full. Here's another story, and with everything going on in the news, this one sneaked under the radar a bit, but I think it is fundamental to please think about this, what's going on. So, there was, in our justice system here in Montreal, a totally secret trial. Totally. So think about this. So the judge, prosecutors, defense attorneys, everything was secret. No written record anywhere. And the media found out about this. It was reported. The fact that it was secret was taken to court. And last week on Friday, the Supreme Court of Canada finally ruled in a landmark decision that this could not go on in our justice system. And for justice to be justice, it has to be transparent. It has to be public. So to let us understand how we got here and the importance of this Supreme Court decision, always happy to be joined by Eric Sutton. He is a criminal defense attorney. Eric, a pleasure as always.
Good morning.
So tell me, how did we get to this? Okay, maybe give us some context on how was it possible to have an entire trial in secret in 2023-24?
Well, the word secret, you have to remember that there are times when proceedings in criminal matters proceed behind what we call closed doors, and they use a Latin term, in camera. And to some extent, whenever that happens, and it's not that infrequent, what's going on, the public is not able to observe what's going on. So there is an element of secrecy to that type of process, and sometimes it's necessary. And
Eric, I would interject here. Give me an example on why would that be necessary?
Well, we have the most frequent example is where the evidence might disclose the identity of an informant. If the identity of a police informant is known, their life is at risk. There could be reprisals. And if you want informants to continue to work with the police, and they are important in terms of solving crimes, you've got to ensure that they feel that their identity will be protected. So if a proceeding continues, and if there's a proceeding that where the identity of the informant could be revealed, the court will order that it proceed in camera or behind closed doors. And what goes on after that, the public and the media are not allowed to actually observe or attend.
But Eric, in that case, the example you're given, and it's true, it happens a lot, and it's a key component in criminal trials. The actual existence of the trial is known. It's the testimony and this person's identity that is protected. The rest is known. We know what the case is about, the proceedings. There are transcripts. We know who the judge is. In this particular instance, I mean, we had none of that, right?
You're absolutely right. What happened in this case was absolutely beyond exceptional. There was no court number assigned to the case. The witnesses were examined out of the courthouse. We don't know where.
Wow.
We don't know who the judge was. We don't know who the prosecutor was, or if there was more than one. We don't know who defense counsel was. It was all done entirely secretly. And for some strange reason, the Supreme Court slammed the Quebec Court of Appeals for calling it a secret trial. It was a secret trial. The only only nuance you could bring is that it started off as a regular trial, and then the accused, we don't know if it's a woman or a man, made a motion for what's called a stay of proceedings and identified himself or herself as an informant. And because of that, what followed was done entirely secretly. So for all intents and purposes, from that point on, it was a secret proceeding, especially the way it was handled. And I don't know why the Supreme Court got so upset with the Quebec Court of Appeal calling it a secret trial. It was.
So tell me about the Supreme Court of Canada's decision on Friday. What did it really say? What comes out of that decision?
Well, it said that what the trial court should have done is is start a parallel proceeding, given that the informant's identity would be revealed. Mm-hmm. They had to proceed in camera behind closed doors. They should have then created a separate file number so that it would be known that there was a proceeding, in fact, going on behind closed doors, and it should just proceeded that way without more. In other words, there would be a record. The public and the media would know that there is, in fact, a proceeding going on, much like what is normally done. And then once a judgment is rendered, the trial judge would have an obligation to review his judgment with the parties to determine what parts of it could be released to the public and what parts would have to remain redacted, blacked out, because there'd be concern that if that information was made available, it could reveal the informant's identity. So that's what the Supreme Court said should have happened. Mm-hmm. The Supreme Court said that in this particular case, we will never know who the judge was. They agreed that the judge will remain secret, the judge's name, prosecutor, defense counsel, and judicial district where it occurred, because there's a concern that if any of that information was revealed, it could be somehow matched to the beginning of the case, which was public, and it might lead to the possibility that the informant's identity could be known. I'm not sure if you understand.
No, I got it. I get it. it. No, absolutely. No, this is a great analysis, Eric. I'm running out of time here. Okay. The one question I want to ask you is, what was the buzz around this case, amongst colleagues, at the courthouse? You guys talk, prosecutors, defense attorneys. What was the reaction to even the existence of this secret trial?
Well, the way it was handled in this case was somewhat of a shock. This is not what the Supreme Court proposed is the way it normally works, and no one really understood why this was handled in that fashion. Obviously, we all would love to know who was the judge, who were the prosecutors, or who was a prosecutor, who was in defense, because they have to take some responsibility for this having happened the way it did. But apparently, the Supreme Court has said that will remain secret.
Because the judge went along with this.
Yes, absolutely. And it was all done in a very bizarre, entirely secretive fashion.
Are you concerned that there might be other cases we don't know about that are similar? That this is not an isolated incident?
It could be. That the problem, the only reason we found out about this is because the individual in question was convicted and appealed. And the Court of Appeal looked at this and said, there's something wrong here. This was not handled properly. And we're going to let truth be known that there was a proceeding in which someone was convicted, and it was not handled correctly. It was handled in a secret fashion that's unacceptable.
Anyways, tomorrow I'll be speaking to one of the lawyers who actually pleaded this case before the Supreme Court of Canada and won. He was representing the media consortium, so we'll have his insights tomorrow on this case. But Eric, I appreciate your analysis as always. Very, very clear and very important stuff here. Thank you.
Okay, my pleasure. Talk soon.
Eric Sutton, criminal defense attorney.